Hello, hello, everyone, and welcome back to another episode of Speaking Legally, where the legal meets the cultural. My name is Dr. Stacey N.C. Grant, and it's my pleasure to bring on today our co-host for the show, Royce Russell Esquire and Ed Pichardo Esquire, as we discuss these matters that are pertinent and important to our community to understand it from the legal lens, but also what that looks like for us culturally. We can see what's happening in the world. You would have to be living underneath a rock not to understand where we are in this country, going on 9 days of what we're seeing happening and what is unfolding literally as this show goes live, as the Attorney General is making announcements about the case of George Floyd. So once again, we extend our condolences to the Floyd family and to all of the families that have unfortunately been a part of this country's history of the excessive force that has led to death of Black men and women. So as we open up the show, I'll let our two co-hosts just say their greetings to you, and then we're going to dive right in real time to what's happening here in America. Over to you, Mr. Ed Pichardo Esquire.
Hello, everyone. Hello, viewers. Welcome to Legally Speaking, where the legal meets the cultural. Once again, my name is Edward Pichardo. I'm a Dominican American attorney based here in New York City. Hablamos español. Estamos a tu orden.
I just want to say hello to everyone out there. Welcome to Speaking Legally. We tune in today, giving our blessings and prayers with those that are out there processing. We know no revolution is ever going forward without some slight of violence. Hopefully, we are past that, and we're now more into the peaceful stage of the protest. But every facet of our creativity needs to be used at this moment. And what we're going to focus today on, and the essence of our show is once again to bring the cultural and the legal together, where legal and cultural meets, where culture and legal meet. And we want to dive into some of the things that we may be hearing about in the future, that is charges that may be levied against the officers in the future, having an understanding of what we, or at least what I think from a cultural standpoint is probably beneficial for the long term, and how do we go about processing this over the long term, whether it's George Floyd, whether it's Ramarley Graham in 2012, you name the name, whether it's those that you haven't even heard of that have been abused and subject to excessive force that did not lead to death. We speak for those today, and we want to give some context to what is to come in the future. So, with that said,
but hold on, Royce. Let me tell you what it's saying. Officers arrested for Floyd's death charged with second-degree murder. 3 other officers charged with aiding and abetting second-degree murder. So that's what's literally breaking as this show is airing.
Well, that's good. That's definitely good to hear. That's a far cry from where we were before. But Ed, I'll let you jump here. One of the things that I just want us to be mindful as a culture is that we don't rush to have them rush to levy charges that may not be inclusive, and gives us every avenue to bring justice to the forefront in every way possible. That means not leaving anything on the table, from the manslaughter to murder to the first degree. Let's examine every single element. And I know it might be heavy on protesters and my heart and the Floyd's heart and everybody's heart that they want to see some type of movement. I just want the movement to be right. That doesn't mean we have to wait 5 years. That doesn't mean we have to wait 4 months. That means arrests can be made, charges can be articulated, but not finalized, so there's room to bring other charges. So I'm glad for the new information. Ed, you was going to say something. I'm sorry.
So for the audience, I echo my colleague Royce's sentiments here. When it comes to the law, everything is about what can be proven. What does the law state? What can you prove? What happens when you match the facts to the law? Okay, let's keep that in mind. So when we talk about, well, what is it that should be done? What can be done? These officers being charged and for what? You have to keep in mind that whenever the prosecutor has to decide what to charge, they have to consider what's called the elements of the law, the applicable law. And when we talk about elements, we mean what specifically has to be proven in order for you to get the ultimate conviction. And it's a legal process. You get arrested, you get charged. The defense counsel may make motions to have certain charges dismissed because the alleged facts don't match the charge. The prosecutor can come back and either agree or disagree or amend the charges. It's all a process. It's all a process that takes place. You also have the situation where multiple charges are charged, and to allow for what will the ultimate evidentiary presentation at a trial show, what is proved, and ultimately either I'll put out this caveat. I'm not necessarily aware of what the current state of the law is in Minnesota when it comes to bench trials versus jury trials. But at the end of the day, there's going to be a trier of fact. Ultimately, if there is a trial, if Officer Davin and the other officers charged don't, be guilty, some charge. Sometimes you will notice in some cases that defendants will plead to a lesser charge, and the prosecutor will allow that to happen in order to eliminate the possibility of an acquittal. So what we have here basically is Derek Chauvin, I believe is the name of the main actor here, was originally charged with Minnesota Statute Section 609.195, which is murder in the third degree. And according to the press, as recently as this afternoon, he is now, the charge has been bumped up to murder in the second degree, which is Minnesota Statute Section 609.19. And so there's also an interesting phenomenon here, Royce, and I don't know if you'll agree. I'd love to hear your feedback on it. Originally, the Hennepin County attorney filed the first charge or set of charges, which was the murder in the third degree, and now Keith Ellison, the Minnesota Attorney General, is now announcing this bumping up. So I'm wondering if now the Attorney General is taking on the case and the local district attorney or attorney in this case is no longer handling the prosecution of the officers.
The Attorney General is stepping in. And look, time is the best element in this particular case. Now, once again, I'm going to have the rubber meet the road and talk about the culture and the legal. Culturally, we're sick and tired of being sick and tired. Culturally, we have known, and it's been our history, that a wrongful death occurs and by the hands of the police, and it takes years and months for anything to happen. So I understand, you understand, Dr. Grant understand, everybody recognizes the frustration from a cultural standpoint on that the wheels of justice move slowly, and 9 times out of 10, at the end of the day, folks who are law enforcement, they wind up being acquitted of the charges. And I'm going to take this very slow because we might be talking about this over a period of time during our presentation today and going forward. And you said a lot. And so I'm going to take it slow again. Now, so we have a choice. We can ask those in power. One, and I say ask because I'm of the mindset that we are now just realizing how we should take hold of our local politics. And we, at this point, are looking at people that are in positions that we didn't put in positions. So I'm using the word ask. Maybe in the next 3 years or 4 years, we won't be asking. We'll know because a guy like you or a guy like me or a guy like somebody we know, a young lady or a woman that we know will be in a position and we'll know what their track record is. So we don't have to ask. But in this particular case, we're asking and we ask those in power to bring charges against these police officers with an S. And we ask that they do it expediently. And that could have been done. 4 days might have been 4 days too long because you can make an arrest and you can allege charges where you don't have to prove it at the current moment. You just have to have the element. And at the very least, murder in the third degree is something that they went forward with and they thought that they can prove and they made an arrest on that. And the aiding and abetting, when they look at the tape hasn't changed. They could have made arrests as to those. Now, whether those people get on, whether those officers are allowed to be out on bail because the charges are not great or the link is not there, that's for the judge to decide. And that's another battle. But as the prosecutor or the solicitor or the attorney general, they should have done that immediately. Now, it is also important, and you mentioned that there is a process. And in every state, the process is different. In some states, you have what they call preliminary hearings. They don't have grand juries, or they have a preliminary hearing before there's a grand jury. In other states, they just have grand juries. And so either way, there's a process for the prosecutor to meet their burden on a legal level before it goes to a jury to say that we've met these elements for the crimes that we have charged them with. And the third degree murder would have been the easiest to go with because, and I'll let you elaborate on this, is that because in that charged crime, you do not have to prove any mens rea, any mental state, any predetermination, any thought, and in reference to your act. So at least you stabilize that a murder occurred and the mental state we can start to build on. And so that was the safest. That shouldn't have been the end, but that was the safest. And where we thought that was going to be the end is part of where the eruption, in my view, took place because we're so used to that being the beginning and the end. The lowest charge, long amount of time before it happens, and then acquittal at the end. And we've said to ourselves that equation has to change. And I think, I'm not sure, I'm not going to put money on it. I think that the equation is starting to change a little bit by the Attorney General taking over. And you're seeing murder in the second degree. And you're seeing now aiding and abetting. But you also see it from a person that resembles and echoes what we've been talking about all along, a face of change. Look who the Attorney General is.
Right.
Look at
and what's amazing is I was watching an interview by Amy Goodman of the Attorney General's son, who I believe is now a member of the Minnesota City Council, the Minneapolis City Council.
That's right.
And apparently he had been a prior activist, and there was an occasion where he was at a protest and this police officer aimed this cannon-like weapon towards him while he was protesting. And, she interviews Keith Ellison about that and how he felt. And, and at one time, I believe Ellison ran for the Senate and he was part of a progressive wing, I believe, of the Democratic Party. So it's amazing how, life goes through its course. And now he's the Attorney General at this pivotal moment. But
let me jump in for a minute there, and before you finish your point. I was listening to Van Jones talk about the fact that Ellison is somebody who is very much led by a moral compass, and that he was going to take his time to make the right choice because that's just who he is ethically. As a person, Van used the words that he would rather die than go against his moral compass. And it's interesting that we're talking about the fact that he was elected and put in a position where he looks like the people that he's serving. But continue on, Ed.
Yeah, I believe he's, I think possibly the first Muslim elected to Congress. Don't quote me on that. But I believe I've read that in the past. But to continue on Royce's point, As I stated earlier, Minnesota Statute 609.195, murder in the second degree. What Royce is alluding to is subsection A states, whoever without intent to effect the death of any person, comma, causes the death of another perpetrating an act imminently dangerous to others. Are we okay in terms of our connection?
Yeah, we're great. I hear you.
Are we okay in terms of our connection?
We're great. We're great.
Hello? We can hear you.
I guess I'll continue. You can hear me?
Yes, we can.
Okay, let me finish. Well, let me go back because there was some sort of interruption in the signal. Whoever without intent to effect the death of any person, comma, causes the death of another by perpetrating an act imminently dangerous to others and evincing a depraved mind without regard for human life is guilty of murder in the third degree and may be sentenced to imprisonment for not more than 25 years.
Now stop right there. Right there. It's important that you said take the facts and you take the element. So we saw the officer knee on throat as if he didn't have a care in the world. So that's where we get the indifference, right? Knee on throat, looked like his hand was in his pocket. He could have been yawning or reading the Monday morning sport. He did not care who was underneath his knee. So that's the indifference. Indifference also goes to the amount of time and hearing the plea of I can't breathe, let me up, I can't breathe, going for your mother. No, he's still going about his business. So there is actual indifference, and I want our audience to understand this, that you can show something actually, and you can show something by way of inference. Actually, you can see his actions. He didn't care. He kept on going about his business. The inference that he did not get up off his neck is also there. So you can infer that he didn't care. He didn't listen to any of the pleas. He didn't react to any of the pleas. So therefore, he didn't care. So that's one way to show the indifference element, right? Now, when we go to whether or not there was intentions to cause death, we start to deviate when we look at this statute, and it may not be the intention to cause death, but it's the intention to cause physical harm, serious physical harm, for which that happened, which then led to a death. So, I mean, without touching all of the elements, you can see how that was an easier charge to manipulate and at least get the officer in front of the judge. We should not be satisfied with that. We should not be satisfied with that. And that's why what you had today is a step in the right direction when you talk about murder in the second degree. And Ed, I'm going to have you jump in here because when we talk about murder in the second degree, that's when we talk about the mens rea, the mental state. Now, some of you guys may be yawning. Some of you guys may go get some popcorn and come back. But we're going to break it down today. You can listen to the tape over and over because it's important and apply it to whatever case scenario you want to. The mental state. So that's where we start to go into first degree and second degree. Premeditation, first degree, second degree, intent to cause an action. And so when we hear that premeditation, I'm going to let you take second degree. I'm going to take first degree. When we hear premeditation, I think a lot of people think you wake up in the morning and as you yawn, you got out of the bed and you said, I'm going to kill an African-American today. No, premeditation doesn't have to go that far. I would submit that even in this case, you try to charge him with first degree murder, where there's a premeditation. That's how expansive and out of the box I would get with it, because when I look at premeditation, I look at the clock of when it started. It didn't start when he put on his uniform. It didn't start when he first encountered George Floyd. It didn't start when he wrestled him to the ground or took him down to the ground. It didn't start when he first put his knee on his neck, but it did start. And it started, and from my view, the premeditation started after the first crime, after the second crime, after I can't breathe, after I don't really, by his actions showing that he didn't give a damn. Those are inferences to me that can make a strong case of premeditation. And as attorney general and as a district attorney of a county, why not put that in front of the grand jurors and see what the grand jurors come back? It's not going to hurt.
Hold on, Royce, before you finish explaining that. So you're setting it up for the ways in which you can make that case. Would it also be beneficial to add that this particular officer had a series of complaints? We've talked on this show before about the importance of making complaints when you are a victim of an unlawful stop or excessive force, because there's a list of complaints apparently that this officer has received before. So would that point that you made in a previous show also be applicable here in litigating this case?
So now, yes and no. It might be applicable in the thinking of the attorney general or the DA as to why to go forward, right? Why to choose this charge internally, why it's the best move, or why I think is worthy of going this way because of the history. But it doesn't determine and is not an element of the actual charge. Now, in a civil case, it weighs even heavier. But the way it plays in the criminal case is that because he had these complaints filed in the past, it makes it very hard for him to take the stand and try to defend himself as if this is the first time this happened. I'm really a good guy. This just happened to be a lapse of judgment, moment of happenstance. When you have a history that is behind you that shows that you have acted in this way before, then that may preclude you and dent your credibility and preclude you from taking the stand to even try to explain that. And so that's how I see murder in the first degree working, and murder in the second degree.
Well, just to touch upon the point real quick before I get to that, in some instances, what Royce is referring to is possibly opening the door. Defendant gets on the stand, says, I'm a great guy, allowing a prosecutor to say, wait a minute, did you just say that? Well, what about this and what about that in the past? Because in many cases, the defense attorney will try to get any mention of what's called prior bad acts excluded, before the trial even begins, by making the argument to any of those prior incidents would be unduly prejudicial and not actually relevant during this proceeding. But let me talk about now murder in the second degree. So what Royce is alluding to is subdivision 1 of 609.19. Whoever does either of the following is guilty of murder in the second degree and may be sentenced to imprisonment for not more than 40 years, sub 1, causes the death of a human being with intent to affect the death of that person or another, but without premeditation. And the sub 2, I'm not even gonna read because that really deals with what's referred to directly in there as a drive-by shooting. And then the subdivision 2 talks about unintentional murders in the event that someone is committing an associated felony offense or engaging in some sort of other, once again, drive-by shooting and so forth.
So hold on.
So the important thing here is
facts to that.
I'm sorry, I'm having problems with my signal. Can you hear me?
Yeah.
Did you ask me something?
Can you hear us?
Yes.
All right. I just wanted you to add the facts to the first statement that you made in reference to the element of the crime. Make the case that there's a fact that meets the element. What is the case?
Okay, so the first element is causes the death of a human being. That's clear.
Yes.
There was a cause. There was an autopsy. There are medical reports. There was the death of a human being. Next, with intent to affect the death of that person. So now you got to prove intent, that Officer Darvin intended that act. And you might use the fact of there was a very long period of time that he spent with his knee on George Floyd's neck, intent. The fact that, George Floyd was already handcuffed and there was no need for that, but it was done anyway. And you could talk about some of the other circumstances and use that to talk about intent here. And also, of course, that was applied.
So intent would be inferred, and we can show intent by way of actions without actually getting into the mental state, without there being a statement that is made that I am going to kill someone today. And that is important.
Okay, and then you then move on to but without premeditation. So in charging murder in the second degree, the prosecutor is not going to have to prove premeditation, which is what Royce was talking about earlier in terms of the plan, the mental state, this was something that was already in the works, apparently the prosecutor has made the decision in this case that, we're not going to be able to prove that here. Whether or not they should be active in their charging is a issue that's up for debate amongst many legal minds, including Royce here. But on my end, my mindset with a lot of these cases has been I'm very reluctant to have prosecutors do what you call overcharge, because I've seen in the past where sometimes that can also lead to an acquittal where there's a bench trial, judge says, oh, you didn't prove your case, acquittal, and these officers are walking out of the courtroom. I'm not going to get into the whole conversation about lesser included. That may be for another episode, but for me, the biggest win in these cases, unfortunately, while I always say hope is eternal, sometimes my hope for seeing these officers ultimately get prosecuted and do time in jail is I become timid. And if I hear that an officer has been arrested and then convicted, for me, in many cases, that's a win, because, it's just so hard. Because then, let's say you even get a conviction, normally that defendant will then take that whole transcript of that whole trial, appeal the conviction, and you may have some appellate court decide as they comb through the transcript, the prosecutor didn't prove this, or this wasn't proven by the evidence that was presented, and then we're going to overturn the conviction, and there's going to be a retrial, and then 10 years later, once again, we're very unhappy with the outcome. So I'm a little conservative sometimes.
Your point, I understand you being nervous. And as a former prosecutor, I've been in the room. I presented those cases to the grand jury. Unfortunately, or fortunately, they weren't police cases, but I understand the overcharging. But when you have people that have gotten the short end of the stick, and in any other place, in any other time, although we know that this has been used against us, we have to accept the fact, and we should want there to be some creative thinking in reference to how one can proceed. And if the justice system is doing what it needs to do, then there will be a jury and jurors out there that would say whether or not the square fits in the circle, or whether the square actually fits in the square peg. And as to bench trial, if there exists a bench trial, the Attorney General in this case and any other district attorney should be wise enough to know that they should not go in there with just one count and go in there with one theory, because like minds don't always think alike. They just don't. And so having a multitude of theories of what took place, I think could be a good thing. I do understand the abuses of overcharging and how that has worked against us at times, but I've also watched people overcharge, and I watched good attorneys like you and myself go in there and knock it down. And because they overcharge, you might do better than what you think from a defense perspective. But we want the process to actually unfold, and we want to be a part of it, and we want to see it, and we want to have our hands in it. And the first level of being a part of it is to pay attention to your local politics, to understand who you're putting in place and in power to do certain things. So you don't have to pray. So you don't have to hope that the attorney general or the solicitor does the right thing. You know it. And because they're doing the right things, and we can go right into the next segment, is that after the presentation and after the charges and after bail is set, then you have the grand jury. And then that's when you could talk about the lesser included and the other charges that you might want to bring forth. But in between that, there can always be what we call a resolution by way of plea. That means someone says that they plead guilty and the case goes away. But we have to keep our eye on the ball all day on this.
Absolutely. So I want to just shout out some of the folks that are watching, and we appreciate you watching, and you'll be able to be here again for the show, 4 p.m. Eastern Standard Time. And thank you, Leonard Murray. Thank you, Sharice Goodwin, Darian Benjamin. We appreciate you. And So Bless Keisha, and all of those who are tuning in. Share this with those who need to know. People want to understand what's happening. Children are trying to understand what's happening. Adults are trying to understand what's happening. And right here on Speaking Legally, this is where the legal meets the cultural. So you understand some of the background of what we're actually dealing with, what has been presented today by the Attorney General, what those charges really mean. And then now we're moving into another part of the discussion. So as you follow along, as you stand on the front lines protesting, as you give your money to those organizations that are helping those with bail, once they do get arrested, you're sharing information on social media. Everybody's doing their part because no one can stand by and be silent in this moment. So we hope that as you hear it, it helps you be able to articulate intelligently about how the justice system is working and what should and shouldn't happen as we see this unfold.
There's two things.
And if I may,
if
I may, no me quiero olvidar mi comunidad latina. De lo que estamos hablando aquí mismo es los elementos del crimen que las cargas que le pusieron al policía en este incidente de George Floyd. Hoy anunció el abogado general del estado de Minnesota que iban a mover las cargas o le iban a subir de muerte en el tercer grado a muerte en el segundo grado. Y la diferencia es que él parece que él tiene la fe que ellos van a poder probar que este policía mató a ese señor con intención. La carga anteriormente no tenían que probar intención, nada más que él causó la muerte de este individuo. El colega mío, Royce Russell, piensa que ellos hasta deben poner carga para muerte en el primer grado, porque él piensa que aquí hay ciertas cosas que pueden decir, prueba que este individuo hizo este crimen con premeditación. De eso es que estamos hablando aquí hoy, para que ustedes sepan y entiendan de lo que se está diciendo aquí hoy.
God damn, I said it better myself, bro. I couldn't have said it better myself. But Ed, I just want to add on to this discussion in that I want to talk about first the other officers, the aiding and abetting versus acting in concert. I think that's a concept since we know that the other officers have been arrested or at least charged. And I'm going to start off with this first, is this thing about venue. You know, part of my heart tugs and pulls and says, and my mind says, let's calm down the protest. Let's calm down what is actually going on in Minnesota. And the why my heart says that is not because of fear for my own. It's fear that in some shape, form, or fashion, the powers to be may try to ask for a change of venue. Take the case out of the county where it is and move it somewhere else. And we've seen that with Amadou Diallo, where the case was in the Bronx. It was moved from the Bronx because of the unrest, and it was taken to Albany. Don't know if it can happen here. Don't want to find out. Don't want it to be a product. And I'm not saying suppress one for the other, but what I am saying is that we have to be mindful that mud could be thrown in the game at any moment. And we've already seen the mud thrown in the game if you haven't recognized it by way of the autopsy, which said that he may have died from other causes, but the actual choking, the actual suffocating, the actual asphyxiating, trying to already put mud in the game.
It's already begun.
It's already, the chess game has already happened while we might be running around playing checkers. So to a degree, we want this case to stay where it is, a jury of your peers. Hello, I'm a peer. I want to be a juror of your peers.
Absolutely. And already when it comes to jurors, let's think about jurors. Jurors are people normally registered to vote. They get selected, they get called, they actually appear, right? And they sit there, they actually serve, they're not trying to get out of jury. So in many instances from the outset, the likelihood of you getting somebody who's, reasonably conservative is already big, even in the most culturally diverse community. So imagine if this case is moved to a venue, to a county outside of that Twin Cities metropolitan area, and you have a more suburban element, even more conservative. They hear this case. God forbid you get a community like Simi Valley, Rodney King, where most of the people in that community are family and friends of officers and sympathetic. Oh no, he couldn't have intended to kill that man. It was a mistake. He just testified that they taught him in the academy that this was the way to restrain somebody, and they put up an expert saying that this is used in many police departments. And look at the video the other day of the officer during a protest who at first had his knee on the protester's neck, and then that partner who loved him to death on his knee and said, "Nah, man, you crazy. The cameras are right there."
That's right. I mean, we've talked about this before, failing to intervene, right? And so this brings us right into the aiding and abetting. So I wonder if my man was thinking when he pulled his partner off, like, I don't want to get down with the aiding and abetting.
Do that. They intervene, huh, Roy?
That's right. And so what I try to tell people, and I don't think a lot of people really want to hear it, but this whole world, everything we do and don't do is based upon consequences, the good and the bad. You teach the dog a trick, he does the trick, you give him a treat. That's a good consequence. Action, consequence. You don't study, you fail a test. That's a bad consequence. I'm all for humanity. I'm all for a lot of things. But when you strip things away, it is an action, and a reaction is an action, and a consequence is a non-action and a consequence. It is do something and something else will fall behind it or in front of it. So when that partner said, get off his neck, he was thinking about the consequences. And as soon as we solidify the consequences in this tug of war between law enforcement and our community, a lot of things will not get rectified. And we've talked about this. Consequences could be criminal charges, financial consequences. It could be a combination of the both. And so now that we talked about venue and we moved into the aiding and abetting, that is the least of the charges and probably the most appropriate charges that they could have come forward with the other people that were around, because that's just something. You look at the actions, we can go into that. I'm seeing a pause button.
Yes, pause. Before you even go, time out. This is the first time in my lived history of what we've seen in America when it comes to the blue wall of silence being broken, right? Where other chief of police, other officers are speaking out against the fact that this was murder. So the aiding and the abetting was very important for those charges to come forth, for us to even hope of a glimpse of the systemic changes that need to happen, because most times the officers throw their hands up in the air. It wasn't me. They're watching it, or they turn their back, or they turn to the side, and they act as if they're not a part of what that other officer is doing. And let's be clear, we're not here saying that every single officer or law enforcement person is bad. No, what we're saying is the small group, those that have caused this damage, those that perpetuate the wrong thing, now it's come to light. Everybody is looking in. That's why this was such a big day when this press conference was happening, to see if those other 3 officers were going to be charged at all. So now that they're charged with aiding and abetting, it's really challenging this blue wall of silence, and everybody else that has turned a blind eye. I hope every officer that is doing good, that is serving and protecting, that is making this a career choice, which a lot of them are Black and brown, let's also be clear, that they want to do the right thing, that now the silence has been broken, because this is going to be a case that will live on, not just in the law books because of how it is unfolding in the global eye, but finally somebody is acknowledging the fact that there is some real responsibility for officers who stand by and do nothing when somebody goes rogue.
And I just want to put forth, Royce mentioned something earlier about power not conceding anything without a demand. Also in this case, the hope is that when you charge those other officers, one of them eventually flips and turns on the others and agrees to testify and strengthens the prosecution of the case. It happened with Justin Volpe years ago when he turned on his fellow officers, and he was broken on the stand by the late great Kenneth Thompson, who was trying that case on behalf of the U.S. Attorney's Office. That can happen here. That's part of playing that chess versus checkers. Because I would imagine that could possibly happen with the officer who was standing trying to block the camera from videotaping, and in terms of, because there were 2 officers plus Chauvin who were sitting on Mr. Floyd, and then you had the 4th kind of keeping the so-called crowd or whatever away, or preventing people from interfering in the so-called arrest. So what are your thoughts on that, Royce?
Well, my thoughts are, one, we got to be very careful. We have to be very careful. I'm all for labeling and moving the ball, but I'm not for moving the ball 5 feet and then get a penalty and got to move it 15 feet back. You see what I'm saying? So I'm a little skeptical. I've been in the grand jury. I've watched this. I've watched cases go on where you have officers in that grand jury room and they're lying and they're doing a whole bunch of things and they walk out. And maybe this is not the case, and maybe that's the small little step where that won't happen again. But I'm very cautious of moving it 5 feet to have a penalty of 15 feet, because we will not feel good if any of those officers are let go with community service, walk out of here with probation, lose their job. We know that doesn't feel good. It is a consequence, and it will put other people on notice, but it's not the medicine that we're trying to have fed to us right now. And when you look at aiding and abetting, you really have to look at their actions. So someone that stands in front of the camera, to me, that's analogous to the lookout person when you rob the bank. Exactly. You only got aiding and abetting. So that guy who's a lookout person who robbed the bank, that should be acting in concert with the bad actor. You got his knee on his throat. You're protecting, making sure nobody can video it. That's acting in concert. You heard the pleas. You're standing in front. So I'm looking at aiding and abetting, and I'm kind of like, all right, I see where you're going, but it could be more. Somebody else who was on the body while the officer was on his neck, that's acting in concert. Acting in concert, the label of that, the term, the phrase gives me a pain in my right shoulder as opposed to aiding and abetting, which makes me just want to crack my knuckle. It's two different things. You know what I mean? It's two different things. And when you start putting acting in concert, oh no. You want to talk about breaking a wall? You want to look, there's really not much that they can flip on. It's on video. It's right there. You ain't flipping on much. So we got all the leverage at the prosecution right now. We see you. As a matter of fact, I don't even want you. I don't even want you. Like, you know, you going about your business. I'd rather make an example of you than use you to get an extra 10 more years when I'm already looking at 15. I can already, you know, prosecute for 15 or prosecute for 10 or prosecute for 25. And you stood there. I may want to use acting in concert. So I just don't want us to rest on our heels on this. This is a slightly feel-good moment, but those that are out there that know the law and know, you know, the do's and the don'ts should be pushing for more, and I'm pushing for more.
Well, yeah, I mean, I completely, you know, respect that. You know, I'm just saying at the end of the day, when it comes time and you know, this stuff can happen in the middle of a trial. You know, sometimes things don't go as forecasted. One of my concerns in this case is as there's a moment that I saw a video of some sort of meeting or activity taking place while George Floyd is in the vehicle. When he was first taken to the vehicle, I believe he was placed in there and then for some reason removed and ends up on the floor. And I don't think that there was any clear, indisputable video there of what occurred during that period. I see the door kind of open. I see some activity, but you know, I haven't seen a video yet of what was going on in that video, and they seem to be riding on this idea of, you know, some level of resisting arrest. So, you know, those are, you know, listen, you've been in trial, Roy, so have I. You know, best laid plans sometimes of mice and men. And, you know, we're just trying to kind of educate the audience of the many things that can happen over the course of this this saga regarding the charging, the trying, and hopefully ultimate conviction of these officers.
One of the Dr. Grant, one of the educations that I want to give real brief, is that be a juror, man. Stop trying to wave your hand to get out of jury duty to go to the job that you complain about that you hate. What are you running to? And there may be some people that don't even have jobs that are being selected as jurors, and they want to get out of there because they got something better to do. Don't know what, but they got something better to do. And I'm not talking about somebody that takes care of the whole household while somebody else is at work. I'm not talking about the male or female or the other spouse that might be in between jobs. I'm talking about those that may not have a job, that are still trying to walk out the door. We owe it to ourselves to be jurors in every single matter. I'm not saying that we have a monopoly on the criminal justice system, but far too many times as a defense counsel, I have defended those that look like me, sound like me, and act like me, and I've watched people that look like me, sound like me, and act like me walk out the door. And that is not a jury of your peers, and it only becomes an issue when it's your cousin Bebe or Ray Ray that is standing next to me. Or is the wrongful death of someone like George Floyd, does it become an issue? This should be on our ticker every day, all day, 24/7, 8 days a week, 52 weeks in a year, 365 days of the year. And for us to act like and not recognize within ourselves our flaws, we better get right.
Absolutely. I've spent
get right for us.
I've spent my entire legal career telling individuals, people, listen, please do not disregard that jury summons notice that you get in the mail. Please serve. Defense attorneys need you. They need you to be on that jury to, judge your peers. It's part of your duty as a citizen, as far as I'm concerned. Same way you have a civic duty to vote because our ancestors died for the franchise is the same obligation we have to serve on juries, because there was a time when we did not get to serve on juries, where we were hung for even trying or attempting or daring to suggest that we were qualified to judge one of our own. And so nowadays, unfortunately, there seems to be a trend of people picking their own, own reasons, in many cases frivolous or selfish, for not serving on a jury. And like you said, Royce, okay, fine. If you have somebody who you need to serve, and you have an elderly person, you have a family, certain circumstances, okay, fine. But most of the time when people tell me that the reason they're not serving on a jury is it's usually something that is just not worth it, and compare it to the importance of serving on a jury and the impact you can have on a fellow community person, member of the community's life, who's hanging in the balance.
Absolutely. We've come to the point where this show flew by because there's so much to talk about, but I want to underscore what both of you have raised as far as jury duty and serving on the jury. And thank you, Tony, for joining. They're saying so true. They are people who go and do their civic duty to be on the jury. Some more of it, no more ducking. We need to be on jury duty. Leonard says he goes every time. So we appreciate you putting your comments in the chat. And also, if there are other questions that have come up through this conversation that you want us to address and have attorneys Russell and Pichardo talk about it, write it in the chat, share this with those who think need to hear it so we can intelligently watch what we're seeing play out with the law. This is where the legal meets the cultural, that you can understand in between the pain, because we're not okay, right? We're all feeling this in different ways. Everybody of Black and brown skin. And, Ed, I'm so glad that you're on the show, because that's a whole nother conversation. They're showing clips of, some of our Dominican brothers and sisters are like, oh, there's no me, but we're all one, right? We come from the same place. We're all subject to what we're seeing, and we have to take a stand and to say something about it. But jury duty is one of those ways that we can be a part of the process, not just in this case, but in all cases. And once again, underscoring the importance of voting. Royce, you mentioned that earlier in the show, that this is important for us to be a part of local elections as well, so that you know who you're electing, you know what they stand for, you know if they'll be fair and impartial, you know if they're really going to focus on justice and equality for all. So these are just some of the things that you get from this show each and every week. As we close out, and I invite both of our attorneys to tell you how you can connect with them. Thank you for tuning in. Please let others know about Speaking Legally, where the legal meets the cultural. We're going to follow not only this case, but everything that's happening. COVID-19 is still very much present, still very much affecting a lot of the issues that we spoke on in previous shows. So stay tuned, more to come. And I'll turn it over to you, Royce Russell Esquire, to just tell people how they can connect with you in the interim until we're back again, and then over to you, Ed.
Well, I can be reached at 718-785-8890. That's 718-785-8890. You can always go to my website, www.roycerussellesq.com. And let me just say briefly before I pass to the Ed, is that part of the solution is going to be education. Education plays a big part in this. And as I look in this world, far too many times we worry about what somebody else is doing, and we're not really taking care of what we need to do. And we need to educate our folks on how to manage the situation, even though we may not be able to control it, how to manage it, and understand how the world sees us. And also, let's understand that George Floyd is a result. What comes before the result is the small indignities that we suffer every day, the discourteousness, the lack of tolerance. Why do I have to come back to this neighborhood? You can't tell me what to do. I'm going to say another word, shut up. All those indignities kind of build to the slap, builds to the hit on the head, builds to the throwing on the ground, builds to I'm going to arrest you if you say another word. Bills to a George Floyd. And we need to recognize that. So we need to redraw the lines, or as I stated before, redraw the lines to where the discourtesy is the linchpin that'll get your ass fired, as opposed to the wrongful death. Ed?
I can be reached at 718-514-9099. I also have a website, www.lawofficeofedwardpichardo.com. Para mi gente latina es importante, inminente importante, que ustedes sirvan como jurados cuando lo llamen para servir como jurados en un juicio. Es importante que tengamos gentes en nuestra comunidad sirviendo como jurados, especialmente cuando tiene que ver casos donde nosotros somos el objeto de la persecución. So, por favor, mantengan eso en mente. Y si tú tienes familiares que están tratando de decidir si van a servir de jurado o no, dile que el licenciado Edward Pichardo dijo que tú debes servir como jurado. So I just want to say so long to all of the viewers. Thank you for viewing today.
Dr. Stacy, one thing. Ed, can you stand up? Let me see your shirt. All right, now we've been here doing speaking legally for some time, but we're here today before Brother Judge George Floyd. That's why we're here today and talking about this subject matter. It is that shirt that moves us on. I'm wearing this shirt, this camouflage, because we are in a time of war.
Oh,
realize it or not, we are in a time of war. And Dr. Grant is wearing the shirt that she's wearing because faith is what's going to take us through. So even though it may have been by happenstance, it's happening right now. And it moves from one to the other to the other. So
absolutely. I just want to shout out a few more comments from everyone. Stephen, thank you. He said, yes, sir. Look at, they're saying that you're the favorite attorneys. Tony B said, okay, I see you speaking in Spanish. Yeah, this is a bilingual show. We have it all, Black and brown people together taking a stand. So stay tuned. More to come next week. This is Dr. Grant signing off. Have a wonderful day, and let's process this together as a community. We're not okay, but we will be okay together. Bye-bye, everyone.